Good afternoon and welcome to national television. This afternoon we are coming to you live again from the grounds of the Temple of Justice in Monrovia. We are here again to bring you live happening from Criminal Code 8, where Councilor Volunteer Kofa and all of are currently being tried by the government of Liberia for Arson that took place on December 18, 2025. So we will engage. Councilor Kofa.
Yes, sir.
How you doing?
We will engage Councilor Volunteer Kofa. We will engage Councilor Volunteer Kofa right after that. So we're being informed that Councilor Volunteer Kofa lawyer advising not to say anything from the legal proceeding today. But we will give you updates from the legal proceeding today that took place in Criminal Code 8 at the Temple of Justice. Today at the Criminal Code 8 Temple of Justice, we have both defense lawyer and prosecution lawyer in court. We have the Solicitor General. We have the Solicitor General of the Republic of Liberia, Councilor Augustine C. Fire. We also have Councilor Richard Scott, who is the county attorney for Mozzarella County. And you also have Councilor Edolfo Kanoa and other councils who are currently prosecuting this case for the Republic of Liberia. And on the defense, we have Councilor Arthur Johnson. We have former Associate Justice Councilor Wiggins Wright. We have Councilor Gineto Masakoe. We have Councilor Madina Wise and Councilor Kumi also representing the defendants. And also in court you have Councilor Volunteer Kofa, representative of Grand Crew County, former House Speaker, former Deputy Speaker, former Minister of State without portfolio. Also we have Dixon Sibo of District number 16 in Mozzarella County. And also we have Representative Abu Kamara. We also have Representative Jacob C. Debbie of Grand Jida County, including Thomas Edris and all were in court. So earlier on we expected to listen to the ruling regarding the 32 count motion filed by Councilor Arthur Johnson to suppress the evidence submitted by the government of Liberia. But on last week, the defense lawyer submitted another motion requesting the government of Liberia to trash the evidence on ground that the Liberia National Police and the National Security Agency, both institutions, are not allowed to investigate criminal matters. So based on that, the judge are planning to rule today. And defense lawyer also said their clients were tortured and sodomized to produce evidence against themselves. Judge Willie Lam mandated the Monrovia Center Court, the Monrovia Center Prison rather, to take the defendants to the GFK, where medical examination will be conducted to forward the report on or before the 9, which was yesterday. But today's in court, defense lawyer said they went to the Monrovia Central Prison, and the prison guard said they were not aware of any of them. So Judge Roosevelt Willett fined each of the defense lawyer $20 each to be paid in the account of the judiciary on or before the 16th of September 2025. So since the defense lawyer requested that the John F. Kennedy Medical Facility is a government-run facility, they do not trust the examination that will come from the GFK. Judge Willie now sent a mandate to Monrovia Central Prison, redirecting the examination to the ANR Medical Facility on 4th Street, Cinco, where the defendants will be taken for examination. According to them, they were tortured, they were sodomized. So Judge Willie now direct the ANI hospital for the next facility that will conduct examination on the defendants and present the report on or before the 16th of September before ruling into the 32-count motion filed by defense lawyer Councilor Arthur Johnson on ground that the evidence submitted by the government of Liberia to be suppressed. So right before the camera you have Abu Kabara, you have Dixon Sibo, and former House Speaker Fonati Kofa just left, but we still seeing the presence. We still seeing the presence of the Liberia National Police, the Solicitor General of Liberia is still here. The County Attorney for Mosorado County is still here, and we will engage the views of Fabien Kuya and that of Peter Tobe. We were there at criminal court, the Temple of Justice, following the proceeding there, but we are still awaiting to have words with the chief prosecutor in this case, Councilor Augustine C. Fire and Councilor Bridget Scott. But as it stands, the grounds of the Temple of Justice in Monrovia is cool former House Speaker Fonatikofa just left, and you still have other accused lawmakers into the Arson case that took place on December 18, 2024. So we want to engage the views of Councillor Richard Scott. But the biggest news today in court is defense lawyers were found $20 each to be paid in the account of the judiciary on or before the 16th of September 2025. And the defendants will be taken to the AMI medical facility on 4th Street, Cinco, where the accusation proffered by them that they were sodomites, they were torture, examination will be conducted, and the report will be submitted to criminal for a temporary justice for onward enforcement by the presiding judge of criminal A at the Temple of Justice. So one of the questions that media practitioners, even those who were sitting in criminal court A listening to this case, is the issue of JFK. JFK is the government of Liberia and is the Republic biggest referral hospital, saying that JFK is a government-run institution and they cannot trust the examination that is conducted by the JFK. Is a huge eyebrow that have been raised in this case. It's a huge eyebrow that have been raised in this case. So we are still watching to see whether the report from the AMI facility will be accepted by the defense team, even though they were in court when Judge Roosevelt Willie directed the superintendent of the Monrovia Central Prison to direct the defendants to the AMI for examination, and the cost will be honored right by the government of Liberia. The cost will be honored right by the government of Liberia. So we are still here. We want to engage the view of Mr. Peter Tope, along with myself. We're in criminal A at the Temple of Justice following the activity that unfold today. So right before here you can see, Mr. Tobe, you were in court today. We listened to the happening in Criminal Code 8. I have two separate takeaways today from Criminal Code 8. Number one is the finding of the defense lawyer, $20 each, and also the redirection of the examination from the John F. Kennedy Medical Hospital to the ANI Hospital in Cinco. What's your take?
Well, we all watch the proceeding. I mean, as you correctly said, but for correction, the fine is not $20 each, but it's $100 each for 5 lawyers, for 6 lawyers in total. But one day was found at $50, which is the Antoni's law. But like the other lawyers, which are all considered, they all were found at $100 each for disobeying the court decisions. And according to the court, they gave credence to the sheriff return, though the defense team took an exception. To the court ruling. But that's the court ruling, and that is part of the law. When the court rule, when you're not satisfied, you take an exceptions, and definitely you can say that will take advantage of the law controlling. So I will not be surprised if they go a step for another remainder rate to overturn the decisions, which will be a rate of statutory consistent with Chapter 16, Section 16.21. Section 16.21 of the Criminal Procedure Law. But it's a heated proceeding, and you will expect this, Aaron. As I said over and over, those that are in this proceeding are high-profile people, and you see some of the lawyers they are brought on board are also to a high-profile lawyer, knowledgeable when it comes to the law. Especially you have a former justice who is part of the defense team, considered Waking the Rights, former associate justice, and then you have Arthur Johnson, which is one of the country's best criminal lawyers. So they are all there, and they are making sure, as they say, that the client's reputations are on the risks. Are on the line. So they want to do everything possible to make sure that the client get fair and just trials. But you listen to the judge. Is that, Aaron, when the court make a decisions, and which of course we expect, as most of the lawyers are, to know this, when the court make a decisions, the first thing is that you obey the decisions, and then the outcome from the decisions is what you can have an objection to, and you have proceeding in doing that. You could go up as you listen to the judge, you could go up, but for you to tell your client, as in connection to the court ruling, that do not go there based on the sheriff ruling, and based on the sheriff return, that is an affront to the rule of law. And so it was based on that the court found them, and then the prosecutions who over and over said we have nothing to hide, though they resisted to it. But the resistance is that to the demand that they want independent investigations, independent examinations. The state said they interpose no objection to that. So they are waiting to go to anywhere they want to go, that the independent, which of course the judge, the court now is the one that recommended at this clinic, this hospital that they will be going to, that is opposite the UN headquarters, to do that. Exactly, so that is the MR to do the independent examination. Even though they took an exception to that, you listen to them, but you need to go there, see the outcome. Probably the result could be in your favor. You don't know, but now you have raised the issue that you object to it, and between me and you, if the defendants fail to go there again, definitely they will be held in contempt, and probably it could be different. The punishment could be different. Probably it would not be a fine. It could be some days at the Monrovia Central Prisons. But there is a long legal battle, then we expect this. A lot of pre-trial motions will be filed. Remember that the court is looking at the determinations of the preliminary examinations before they can make ruling in the defense team applications that they file before the court to suppress all the evidence. The issue that the court is seeking for is issue of facts. It's not issue of law. But the rest of the issue that were filed in the motion that NSA cannot come in, that's issue of a law. And the issue about gathering the evidence with the defendants with all a search and seizure warrant are all issues of law. But the issue about our torture and then our sodomite, that is issues of facts. And so what the court need is that a medical report on that, which of course that will explain whether there were torture or there was sodomite before the court can make a sound determinations in connection to the 33 counts that they filed before the court to suppress all government's loyal pieces of evidence that they heard on them in connection to the December 18, 2024 incident at the Capitol building at Arson.
Today, on Monday, if my memory is serving right, we were here and reported that today in the judge here today will be a ruling into the 10-count motion filed by the defense lawyer.
Not 10 count now.
32 counts.
32 counts.
32 counts.
No, 33 counts. 33 counts. Yeah.
Now that again, the ruling has been suspended to the 17th.
18
of this
yeah, next Thursday.
Yes. So I mean, what Liberia should expect from this, even though you're not a judge, you have been here for a couple of times, following notable cases. What Liberia should expect from this ruling?
What I want for Liberian people to have in mind is that you got to be patient. The issue of court proceedings, it takes time based on the facts and circumstances, and looking at the defendants that are involved. As I said earlier, you will see the defense team at pushing a lot of legal issues, and these are grounded in law. But at the end of the day, they will reach to a point where the defendants will have to respond to the indictment, or the matter could be dismissed. But I don't foresee the matter dismissing at this point of time. But they will reach to a point where the defendants will have to respond to the criminal indictment, the fact that they are being indicted. The state believes that they have the evidence to prove a prima facie case against them, even though they are seeing that the state evidence were all gathered outside of the law. So wait and see. So all I want Liberians to do is that to be patient, not to be sentimental, to watch the proceeding, listen to all the comments on Facebook, wait and see what will be the court decisions. Though some are saying the case is political, yes, that they're viewed, but the court has said over and over that this is not a political case, because if it was a political case, definitely the judge, as he said, Judge Roosevelt, who is the resident judge of Criminal Court A, he said that he would not be here. So that is not a political case. And then he said that all parties will look up to him because he will rule consistent with the law and not outside of the law. So wait and see how the proceeding will go. But I mean, for me, it's not surprising to me. I've been here for a long period of time and watching a lot of high-profile cases. These are all what you would expect. A lot of pre-trial motions. Some can be on legal technicality, some can be based on the issue of law, and some can be based on just the delay, the court time. But when you have a judge who don't understand how to move with such a proceeding, he will take his time, go through all these motions bit by bit, and then at the end of the day, we'll arrive at where we want to go, especially where the defendants will have to respond to the criminal indictment. As long as the defendant responds to the criminal indictment, then the stage is now set for the legal battle. But for now, we stay on the surface. We are not reached for the case to go into for them to go into the merit of the case.
How soon? This is a notable case. The individual involved, especially the former House Speaker, this individual who has served Minister of State, former Minister of State without portfolio, he served as Deputy Speaker, he served as Speaker, and now he is in court for Arson on the seat of the legislature where the one sat and reside.
Yeah.
I mean, how soon do you expect to go through the proceeding in this case? These are all pre-trial motions.
I think it's just about time. And as I said over and over that this matter will go into full litigations. And I think these motions that have to do with the issue of torture and solemnizing, I think that will be the last motions, even though other motion could count, but that will be in the trials where they will have the objectives, one or two teams. But when these motions is done with, definitely, I think the trial will go into full swing, and then the defendants will be allowed to respond to the indictment. The next thing is that it's a selection of jurors, and that is one of the proceedings that will take a lot of time because, as I said, over and over, all the prospective jurors are in there. Definitely, all of them will be rejected because they have some knowledge about the case and seeing how both parties argued. some of them could be carried away. So I definitely want to believe that most of them will be rejected. But we are not too far again. The 18th, which is next week, the reports will be coming in. There will be ruling. And Judge Roosevelt Willis, who is the resident judge of Criminal Code 8, will definitely rule consistent with law. Even though, as some are saying, that probably the way how he proceeding with the case is not in, especially the defense favor. But I think his ruling is based on law. And if you have any issue, you could take flight to the Supreme Court. The defense team has gone to the Supreme Court to the judges in Chimot on one occasion for this identical case now, since it was transferred to Criminal Code A, that they issued about to compare him to do the right thing on the issue of the bond. And when it went there, the justice who is presided in Chimot and Jane Santa Wolokoli, Associate Justice in Janta Wolokoli, she declined to issue the alternative rate. And then they are done with this matter. So we are not too far from it. It's just about our time. And we are reporters who are here. We have to take time to follow the proceeding. We are not lawyers, but listen to what all that will be said in open court and report as it is, not to bring our sentiments into this matter, but to just to just report as the proceeding is going on, how the judge rule, what the defense say, what the prosecution say, not to leave anything out, and so that the public can be informed as to how the case is proceeding at Aaron.
When it comes to your observation today in court, have you seen Council Arson Johnson as usual and very active in court? Have you seen that zest?
No, remember that he came at the time. You know, most of the lawyers are in the case, they have other cases that they are in other courts with. That's part they are into this high profile case. So probably he could be attending another case of his own personal case, and then he was able to come very late when the proceedings were going on, because we came at the time representations had already been made. And what have you? I don't know whether you want to talk to us, but on most occasions he said that you all want to reserve comment. I just want to say welcome to ERBC.
Thank you very much.
Well, ERBC, SG, we listened to the proceeding today, and from your account it appeared that the government have nothing to hide over and over. For one fact, the record is clear that the state is the one that prayed for the assignment into this matter, and then two, the state has also surrendered all evidence to the defense team, meaning that you are prepared for the matters and listening to your submission today in court that we have nothing to hide. We cannot go for independent investigations as to the medical that the defense is seeking for in terms of being tortured and solo mass.
Absolutely, there is all others that truth cross to the ground shall rise. There is nothing we have to hide. They will be caught. Nothing within that. Let me tell you, if you say somebody was disturbed in court, how does that follow the evidence that was collected? The phone were collected from them, obviously analyzed, and the evidence here. You say after that, then the people went to prison, they were disturbed. How is that cognizable before the court to warrant the ruling of suppression of evidence to be delayed? But the judge, in particular, the judge wants everything to be very, very transparent. We want that to be done. We pay for it. We want their people to go to wherever they want, so that they will know that we are not hiding anything. And we told them we have more than evidence to prove our case. So we are the state.
What were this issue of torture which the defendant keep talking about?
There is nothing in torture. Nobody tortured them. They knew from here, they went to the court. From the court, they provided the evidence. How would a man provide the evidence before you carry him to torture him? Torture him to gain what? There was nothing. There was no need for torture. They have provided the evidence, their phone were analyzed, and so there was no need for torture.
The court had designated a clinic for them for the defendants to be taken to, but you listen to the defense, one of the defense lead lawyers, Counsel the Waking Right, he objected to that on grounds that it's similar to JFK Medical Centers. What do you have to say about this?
That was sinful submission. That was a very sinful submission. JFK is a qualified place, more than any other place in Liberia, to conduct forensic investigation of any kind. Now, if you say you don't want JFK, we agree you don't want JFK. Another area designated by the umpire, go there. We pay. Then you say you don't want that place. Maybe they will want to go in heaven to do forensic examination of their self-claim, self-proclaim or torture. They were not torture.
So, Eji, before I take leave for you, why you think is the problem? Because the defense team continue to file a lot of pre-trial motions when this matter is awaiting to move into full swing as you anticipated.
I have been criminal lawyer for long. You know, when somebody does not have a case, they cry more than any other thing. They have told you that we don't have any evidence. Nothing we have. Now, when the evidence came, now they're crying. So they will keep crying and crying and crying. They are crying, baby. What they can do is to confess. That would be and rebuild a mansion. If you have to go to jail and build a mansion, build a capital building, you do that. Confess. There's nothing else they can do but to confess. Evidence are overwhelming. They have nothing to do. They have to confess.
So that means with all these, are you sure you're going to win this case?
Well, winning the case is something that I'm telling you. You are telling me the question I have answered. I should answer it again.
Yes.
There are overwhelming evidence. There's nothing we can do but to win the case. Thank you so much.
Aaron, you just listened to the Solicitor General. You have a brief a comment on the entire proceeding. And one thing he said is that they have a competing evidence. Over and over, he has been saying that even though he has been shying away from ELBCs over. But now you listen to him that they have the evidence to prove their case, and they believe that they can prove the case in court. Aaron.
Yeah, and I actually admire how you sing wishing today.
Okay.
Many a time we are trying to engage a few, but you escape. But I mean, one thing you said that the government of Liberia have overwhelming evidence. That's one thing, I really think that's my takeaway.
Though we are journalists, but the fact that they can give 2 plastic buckets to the defense team to the defense team ahead of the trial, meaning that they are prepared for this case. And one thing I want the public to know, Aaron, I'm not the mouthpiece for the Ministry of Justice, but they filed a petition before the court telling the court that we want for you to assign this case for hearing. And based on that request, the court signed the case, and then they produced the volume of evidence I told the defense team, meaning that they are ready for litigations to give these defendants. They are 14, even though some are out of the bailiwick of the country. They have some in their possessions, including the former House Speaker, and they believe that they have the evidence. They are already surrounded it. Whether it's good or not, the court will determine that when the trial begins. Remember that they will pray for a jury trial and not a bench trial. They already had a problem with the judge, but they didn't succeed upstairs. But so I'm anticipating that they will definitely go for a jury trial. And so let's wait and see how it goes. But you just listen to him that they have a sufficient evidence, overwhelming, as he rightly said, to move with this case. So you could join.
We have that. So I mean, yes. So the final words, yes.
My final word is that to the public is that let's keep following this matter. We should not bring sentiment into it. Those that are on trial are all Liberians, respectful people. And one thing I always borrow from the former Solicitor General, Councillor Betty Blamo, she always say that acquittal is justice. So in that it means that you should be convicted and before justice comes. Because the fact that you are coming to court is to prove you're innocent. And all those are being indicted, they presume innocent until a court of competent jurisdictions can bring them down guilty, and then probably they could go up to the Supreme Court, and the Supreme Court can see all of us as to how the entire proceeding went on, what are the evidence that were gathered, what is everything was consistent with law at Aaron. Thank you very much for having me.
Thank you. So thanks a lot. He is Peter Tobe, a veteran judicial reporter who have been here for a couple of years following notable cases. So folks, we love to come to the end of this broadcast from the grounds of the Temple of Justice in Monrovia. Judge Roosevelt Willie again had suspended ruling into the 33-count motion filed by defense lawyer to suppress evidence submitted by the government of Liberia through the Ministry of Justice. And also today in court, the judge of Criminal Court A at the Temple of Justice found each of those lawyers representing the defendants $100 each to be paid on or before the 17th of September 2025 into the account of the judicial branch of government. I've been here bringing you this live happening. Thank you so much for following. We will bring this broadcast to an end and resume in subsequent time. I've been here, Aaron Talu. We spoke with the Solicitor General of the Republic of Liberia, Councillor Augustine C. Fire, and you also listen to Peter Tobe, who have been here for a couple of years following top legal proceeding. Thanks for listening and thanks for watching national television.